for a little while, and so you understand, I think, a little bit about the flow. Ms. Smith will swear you in, ask you a bunch of questions about you and your case and your rights. You need to answer those truthfully and completely. You also should let your lawyer or me know if at any point you've got a question. Will you do that?
Yes, sir.
Excellent. Let's get started.
Judge, before we start, would you like to know about the reduction in this case?
Always.
Count one will be reduced to battery. That's OCGA 16-5-23.1.
All right. So we're moving forward with a misdemeanor.
Yes. Mr. Brown, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Tyrus Rashard Brown.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
36, master's degree.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, I understand.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, I did.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Absolutely.
Counsel, are you satisfied that your client has a full understanding of this proceeding? Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Brown, do you remember being arrested on these charges?
Yes, I do.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 12 months probation?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on this charge?
Yes, I do.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, that your probation or parole may be revoked based on you entering a guilty plea today?
Yes, I understand.
Are you a United States citizen?
Yes, ma'am.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded nolo contendere or guilty or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, I haven't, ma'am.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, I haven't.
Has your lawyer explained what the First Offender Act is to you?
She did.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on probation, your first offender status could be revoked, you could be adjudicated guilty, and you can be resentenced up to the maximum sentence for this charge in this indictment?
Yes, I understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea? Mr. Brown, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No, ma'am.
As to indictment number 25 SC 005798, how do you plead to the reduced count of battery for count one?
Guilty on the effort.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Of course.
Are you aware that even if you do not admit guilt, this is a guilty plea and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a direct right to appeal from your guilty plea conviction, But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Understand?
Do you understand that that process has to be completed within 30 days from today?
Yes.
Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Okay, thank you, Mr. Brown. Your Honor, if this case were to proceed to trial, the facts would show that on June 2nd, 2024, one officer, Officer Chandler of the Atlanta Police Department, was dispatched to 3478 Lakeside Drive, Northeast Atlanta, Georgia. That's also in Fulton County. When the officer got there, he spoke with the courtesy officer that was on duty, Officer Jeff. Security Officer Jeff told the officer that Miss Mariah Howard, who is the victim in this case, she came down from Mr. Brown's apartment on an elevator. She was crying, her eye was bruised, and she was asking for help. In this case, the security guard called EMS and the police to the scene. When the officers got there, they got a chance to speak with Miss Howard, and she told them that she came over to Mr. Brown's apartment around 10 p.m. that night to visit him. She also stated that she came over to do some laundry. I believe she was in town, and where she was, something with the city was happening, so she couldn't watch where she was. So Mr. Brown allowed her to come over to wash those clothes. When she got there, she stated that they were conversing, they were having conversations, and that she eventually gave Mr. Brown a hand massage. Once she gave him a hand massage, Mr. Brown then asked for sexual intercourse. When she refused, Miss Howard stated that when she refused, Mr. Brown in this case started hitting her in the face, causing that bruising to her eye. At this time, Miss Howard was being seen by EMS Grady, where she was later transported and treated for the injuries to her eye. Mr. Brown the officers then went up to Mr. Brown's apartment, where he told the officers that Miss Howard came over. They had met on Instagram a few weeks prior. So when she came over, they were drinking, smoking, and they had sexual intercourse. He showed the officer a video that was evidence of the sexual intercourse. He stated that when Ms. Brown came over, they had a few drinks. She became belligerent and loud in his home. At that time, Mr. Brown asked Ms. Howard to leave. She refused, and then Mr. Brown stated that she had just did something else with his friends a couple of weeks ago, kind of telling her about something that he knew at that time. He stated Ms. Howard got mad at him saying that and started to hit him. And in response, he defended himself, but that defense caused the bruise to Ms. Howard's eye. When she went to the doctor, they were able to assess that bruised eye. They saw that she had damage to her cornea, so her eye, she was hit and bruised pretty serious. At the time, on that day, Mr. Brown was not taken into custody. A few days later, I believe like a day or so, Ms. Howard went to the Atlanta Police Department headquarters, told them about what happened. The detective that she was speaking to then at that point took out warrants for Mr. Brown. He was taken into custody a couple of days after that, where he was charged initially with aggravated battery. Again, this happened in Fulton County. Regarding the negotiated plea between the state and defense, we've agreed to a reduction to battery for 12 months probation, for special conditions to be for the defendant to complete an anger management course, for him to pay restitution to the victim for her medical bill and expenses. I do have all of those receipts. I have to send them over to Ms. Rios. However, that's estimated at about $4,000. So we would just like to have that restitution here and as soon as possible, since the probation in this case will probably only be 12 months. The state is also asking for the defendant to stay away from the victim in this case, and also to complete 30 hours of community service. It's my understanding that the defendant is taking his plea under first offender, so we won't be asking for a bid date or anything like that, but just making that note. Regarding the reduction in this case, because it is injuries that the victim got in this case, and I've talked to the victim multiple times about how this process works and kind of the reason why we were reducing it. The main reason why we were reducing it was because unfortunately there was some inconsistencies in the original story that was told by Ms. Howard on what happened, if she had anything to drink, and kind of the relationship between her and Mr. Brown. From the evidence that we have and looking at the totality of the circumstances, the state did not feel like proceeding on the aggravated battery or hence going to trial would be successful based on those inconsistencies. I did talk about that reduction to Ms. Howard and also to her mom, Ms. Foster. They are not happy with the reduction. They disagree, rightfully so. I understand that, but I did explained to her the reason why we were reducing the charges in this case and the weaknesses that the state kind of had that would make it harder for us when we went to trial. But she is here today. She's present. She's been here at every court date, and she would like to be heard today. That's
Okay.
all from the state, Your Honor.
Got it. Thank you for sharing all that. Ms. Hardy, do you have any criminal history information on Mr. Brown?
We're showing 2 arrest cycles, no felony convictions.
Can you tell me about those 2 cycles?
Yes, let me pull those up. Okay, in December of 2021, there was an arrest for a fray, but it was no pros. And then the other one is this case that's on the calendar.
Got it. Thank you so much.
You're welcome.
Ms. Rios, before I hear from Ms. Howard, there's something you need to say?
Well, it was part of the negotiation was also that it terminated after he completes all the conditions.
That's correct.
Okay. Meaning if after anger management, after the community service, then he could apply to have the sentence terminated.
Yes, we did. The only portion of this, we will talk about that later, is that we're asking for no community service and we'll explain why, but the anger management and the payment of the restitution.
Okay. I'm not including the restitution yet unless you don't dispute the dollar amount. I thought that you hadn't received the paperwork.
We haven't received proof, but we're
Got it.
anticipating that if there's proof, we would have no problem.
Got it. Okay. And then that would become a condition, and payment of that would be something that would have to happen before I'd consider early termination.
Yes, sir.
That makes a ton of sense. Ms. Howard, hey, it's good to see you again. I'm going to ask you to come on up and sit in the middle seat at that table there. Is there anyone from your office who can sit with her, or do you want to? Great. Okay. Good. Good morning, Ms. Howard.
Good morning, Judge.
I appreciate you being here again. And I would very much like to hear from you about this case, how it's affected you, and your thoughts about what should happen.
Thank you. Your Honor, I am tired. I have been coming up here for the past 2 years. And just a little bit about the case. I wrote some stuff down. I was attacked by Tyrus Brown, who is the defendant, in June of 2024. And I have followed procedure to file a police report. You know, they came, that was mentioned. And I did leave with the ambulance, where I suffered from a orbital fracture, which has caused me to have flutters in my eyes, which I will forever have. Those are reoccurring black dots in your eyes where you, see things. And so I have to have corrective lenses. And I've been seeing multiple eye doctors about that. The investigators determined that Tyrus did wrongfully assault me, and he was arrested and given 2 charges. I have tried to seek a restraining order because I did not feel safe here. Living in Georgia by myself. And so I relocated temporarily with family in Alabama. And from that point, trying to get a restraining order, I reached out to the Victim Advocates Program, and I was given an advocate who did not make any contact with me. I texted her, I called, I left messages with the office, just about my hearing, but just about his hearings, because I would like to attend. No response from anyone. Going forward, the only reason I really have knowledge of everything now, because of this year, I've been speaking with Ms. Smith, and outside of doing my own investigation where I've talked to lawyers and they've gave me information about court dates. The district attorney office is proceeding against Mr. Brown, and now they have dropped the 2 charges down to 1. And Ms. Smith did express to me her reasoning because she felt that before she dropped it to a misdemeanor, it was a felony. And she expressed to me that she felt that it would stick and be more beneficial for my case. But as of this month, April, moving forward, it has dropped to a misdemeanor. And that has changed our entire plea agreement, which I just find as injustice for me. We had agreed on the terms of a 10-year probation period, the mental classes restitution, no contact. And now it's just the new terms are a misdemeanor and the same things as far as the no contact, the restitution, and the classes. I just feel like there's no due process on my behalf, and I feel like I am being discriminated against on my gender and my nationality. I just strongly believe that there's just a lot of misconduct with my case. Mr. Brown has been arrested for fighting back in 2023, and like I said, I have permanent damage to my eyes. And not only that, I have physically and mentally changed. I have attended therapy for the past 2 years, given to me by Grady. That's a free program that they offer. And sometimes I was not given transportation, so I had to provide those on my own. And like I said, I had relocated to Alabama. I'm from Mobile, which is about 6 hours away. So I'm driving back and forth. Sometimes I'm being told that the case is being, he hasn't taken a plea, or that date was changed for him to take a plea. So I'm just coming up here and I'm not getting anything. I just want to mention, sorry, I wrote this here. Mr. Brown has taken part of my life that I will never get back as far as my vision. I have come to terms that everyone cannot stand strong or understand the power of discernment, but we are here today because a man cannot accept rejection. Okay. When you have done something wrong, usually you are disciplined. In this case, I feel like this is injustice. This is the state versus him, but this is him versus me because I am defending myself. I have made so many trips to Georgia and with no results. I feel like there has been a lack of care or concern for my case, and this is heartbreaking. How does one cause physical harm to someone and allow to use their first offenders? I don't believe he should be given that option, as he is fully aware of his actions, whether he says it or not. And there has been many conspiracies against women, and this will never end. Because things have been said as far as inconsistencies, whether I said that, I may have said things to Mr. Brown, the reason why he attacked me. But from my understanding, I have never met Mr. Brown up until that day. And when I talked to Detective Scott, she has every message from the time leading up to me meeting Mr. Brown. So he has never met me, but he planned to meet me. And yes, there was someone had hit a power line. So I believe the water was off in the city. So I did ask him when I made plans to meet him if I could wash my clothes there. So that's what resulted in me having items and being there. And Mr. Brown failed to have discernment because I did. I knew that I did not want to have any physical interactions with him that night. And so, yes, Mr. Brown has a conspiracy against me. He may know someone I have had relations with in the past, so he assumes that because I have done things with another man that he has that right. You do not have that right. And, if you guys decide that, you want to keep the misdemeanor, there's nothing I can do about it. But I believe every dog has their day. And Tyrus, you will have your day. And that's all I have to say.
All right, Ms. Howard, I appreciate you sharing that. I had no idea you were commuting all the way from Mobile to get here. But that shows me that you are very committed to what you think justice is. Tell me what you think justice would be in this case.
Well, I believe when we first talked about his sentencing, it was 10 years probation. And I think that was the maximum amount that he could receive. And I do believe that he should still be given that. He should not be offered a first offenders because there was 2 charges. Whether or not he has other convictions in his past or other arrests in his past that weren't convicted, if we would have kept those 2 charges, I feel like he would not be allowed the first offenders because APD investigated and they felt that he did wrongfully assault me. So if he was given 2 charges, why are we offering him a misdemeanor? I asked for those charges to be brought back. Well, that 1 charge, so we would have 2.
Got it. Okay. Well, I appreciate you sharing that and you standing up for yourself. That's not easy to do. You're brave and you're persistent. And I hope those traits help you as you try to move forward in Mobile.
Well, I am relocating back here. I am
Whenever you choose to move forward. Okay. Well, we welcome you back to the Atlanta area. Are you back now or you will be?
I'm back.
Okay, good. Well, I'm glad you're back and I hope you're finding your footing. And like I said, I appreciate you sharing what you shared. It's important that I hear from everyone who was involved.
Thank you.
You're welcome. Ms. Rios,
I'm not sure how far you were able to get into what letter.
read the whole thing.
Okay. Well, just to reiterate, he has a 9-year-old son that he's taking care of. He actually put himself on child support. He sees his son often. His son lives in Memphis, but he flies him out to see him, or he goes to see them. That's where he's originally from. He struggled a lot growing up there, helping his mom, who has since passed, dropping out of school, has helped her. Getting his GED, then going to community college, then university, then getting his master's degree. So he's worked really, really hard to be able to provide a good life for his 9-year-old son, so he have be a good example for his child. So he's also self-employed. He works as an independent construction worker, independent insurance agent, and he's been trying to get government opportunities, but because of this on his record, he hasn't been able to do that. That's why we were asking for it to be under a first offender. I know it's not usual to do that for a misdemeanor, but for in his case, going 36 years without having any convictions, misdemeanor or felony, it makes sense for him. And also to see, we're asking for it to be sealed on the front end, so this will not affect his ability to keep being able to obtain jobs, because he said they've done background checks and this has been really difficult. Now he's accepting responsibility for what happened as far as him letting someone come over to his house that he barely knew, them having an altercation. He still maintains that she attacked him and he was trying to defend himself. It was a thing where she's hitting, he's flailing his arms, and yet the injuries were there. We're not disputing that she had injuries. He's saying that he doesn't go around hitting women. This is not of his nature. He understands that he had responsibility of putting himself in that position. It is under Alford because he didn't try, it was in self-defense. He didn't try to hurt. It wasn't malicious, but he understands that he should never have been in this situation in the first place. I saw the evidence in the videos, and they initially did not arrest him because they were like, it's too much going on here. Officer said on the camera, her story doesn't completely make sense. They said something obviously happened, but it's too much to figure out right now. She gave multiple different stories and it just was confusing to the officers. He was actually he called 911. And so I heard the video of them 911 calling him and asking him if he went to press charges against her. And he said, no, I just want to move on. And he thought that the situation was just done and everyone was moving on from that awful night. So I've talked to Mr. Brown numerous times about it, because initially he's like, I want my day in court. I want to have a trial. I don't want this to be like known as I'm hitting women because I didn't do this. But as going back and talking with the state, he agreed that this is the best option to avoid trial, because you never know what a jury is going to do. And the injuries, there was an injury. So that's why we're asking for it under Alford. He has no problem paying the medical bills if there's proof of that. He just wants to move on with his life. And so the only portion that was not negotiated was the community service. And he's saying that because between the contracts and between him seeing his son who lives in a different state, he doesn't be in the anger management. He doesn't believe he'll be able to do all that within the 12 months period, or it would be too much for him, if that's what you're saying. So I'm hoping that we can not do the community service and we can do the anger management. And honestly, initially, when I was taking him, when I showed him, I actually sent him the offer. We've got to put that in the email, so he agreed to everything. And then later, I'd be like, I mentioned the community service, but that wasn't a part of what I relayed to him. So I understand why he was like, wait, whoa. So I'm hoping that we can do it under first offender, out for plea, with the anger management, restitution, and terminate after that is all completed.
All right. Ms. Smith made reference to there being some type of video evidence that there was intimate contact between the two. I don't want any details, but I'm curious if you agree with that, if that was news to you.
Video, the end.
But you heard that there was one, or was it the first time you heard of it when Ms. Smith just said
That
that?
was on the body camera.
The detective, the police filmed something happening?
No,
I
he
showed.
showed him, they asked.
So Mr. Brown said, let me show you some proof of my version of events.
Yes.
And played something that may have been on body cam.
Yes, Your Honor, because
Okay.
he only did that because she was saying that.
I understand why he did it. I just, people sort of glided past that, but that to me is, call it physical evidence of an inconsistency in the versions of events. I don't need to see the video, but if it was more than a hand massage, then that's different. That's a different version. Okay. All right. Mr. Brown, I've read your letter. It was very well written. You have overcome a lot. You're also in this situation. And as a result of this situation, Ms. Howard was pretty seriously injured with what's leaving her with some permanent conditions. Is there anything you want to add beyond what was in your letter and what Ms. Rios has said on your behalf? You don't have to add anything at all, but I need to give you that opportunity so you can't say later on, well, I didn't get to tell the judge X.
I'm gonna just leave him in God's hands. I know what happened, and I'm gonna just let God do his thing.
Okay. That'll happen a little later. I'm going to do my thing now.
I guess.
But Mr. Brown, I do find there's a factual basis for your plea. This would have been a messy trial for the state and for the defense. It would have been all over the place for the jury. They would have been confronted by a very, someone who would, I think, arouse compassion from the jury with Ms. Howard's presentation of what she's been through. If you chose to testify, I think they'd also understand that it was more complicated than it might seem on the surface. And so I understand why two things are happening. One, that the state is going with really what was the second charge. I do want to address one thing Ms. Howard brought up. This notion that somehow it wouldn't be first offender eligible if there were still two charges. You were originally arrested for battery and aggravated battery. The state went forward with just one of those charges, aggravated battery, and here we are back to one of the things you were originally arrested for. Had the state indicted you for both, you still could have been eligible for first offender. It has not to do with the number of charges, but whether you've ever been convicted of anything before. And you were arrested for something before, back in 21, that was dismissed by a different office at a different time. And so you are 100% eligible for first offender. And I want Ms. Howard not to think that some decision Ms. Smith has made about changing the charges suddenly makes you eligible. You could have had 100 charges and pled to all 100 charges today, and you'd still be eligible for first offender. It doesn't have to do with number of charges. It has to do with whether you've ever been convicted before, and you haven't. So I think first offender is appropriate. I am glad to hear that Ms. Howard is back in the community she wants to be in, and that she continues to get counseling. I think that's important. And I appreciate her desire just to move on, but also to be acknowledged that she endured something and went through something, whatever that something was. I wasn't there for it. I also appreciate, Mr. Brown, your devotion to your son. I have sons, and they are very important in my life. And you are moving mountains to be present, even though just because of the relationship you have with his mom, you got physically present all the time. I think that's a good thing that you're doing. I'm accepting your plea. As I said, I found there's a factual basis for it. I also find that your plea is knowing and voluntary, meaning you've understood what we've discussed. And while you are not enthusiastic about it, you are deciding of your own free will to go forward with this plea. Is that a fair statement?
Yes, sir.
Okay, then I'll accept it. Ms. Smith, can someone in my office sign the indictment for you? Ms. Rios? Yes, sir. And Mr. Brown, can we electronically sign your name indicating your offered plea to the reduced charge of battery?
Yes, sir.
So we're back really where we started with what the police arrested you for. Mr. Brown, I'm going to sentence you to 12 months to serve 1 month with a balance on probation. You'll get credit for the month you've already served. You're not going back into custody, but you will have 11 months probation. Special condition number 1, no contact with Ms. Howard. Don't write her, don't text her. Insofar as you have shared connections, don't use those shared connections to get word to Ms. Howard. Whether it's a word of outreach, I'm so sorry, or it's a word of how dare you say something like you said. If she brings evidence to the state and the state brings it to me that you were trying to interact with her in any way or using someone else to interact with her, that's going to be the quickest way to have your probation turn into custodial time. Understand?
Yes, sir.
Special condition number 2, you'll complete an anger management course. You need to do that within the first 4 months of your probation. I am going to impose the community service. It's only 30 hours. You have 11 months in which to do it. That's about 3 hours a month. And I read your letter. I know you're busy. You're going to be able to take care of that. I'm not saying anything about restitution yet because Ms. Smith needs to get that paperwork to Ms. Rios so that the two of you can look at it, confirm that it relates to care that Ms. Howard has been receiving for her eye injury and counseling related to all that. If it does, it's likely that I would say that's restitution, and it sounds like you're prepared to pay it. As soon as you complete anger management and the community service, and if there is restitution, you pay off that restitution, I am open to consider having your probation become unsupervised. So you're under the sentence, but you're not needing to check in with the folks from probation. I don't think they're going to have an issue with you going to Memphis, but you should check with them first. And if they need a green light from me for you to go to Memphis to see your son, you have that green light. But you just need to understand the dynamic may be that you call probation to say, I'm going to Memphis next weekend, going to visit my child, or next week, or however long the trip is. You just may need to get that green light in advance. They may say, because it's a parental visit, don't worry about telling us. But do check with them before you make plans to leave the state of Georgia. Yes, and follow whatever their rules are. And if their rules are they have to check with me, I'm letting you know in advance. You're not going to get a no from me if it's a trip to Memphis. A trip to Vegas is something different. I need to understand why, but I get why you're going to Memphis. Okay?
Thank you.
Ms. Smith, anything else from the state?
Nothing further, thank you.
Anything from you, Ms. Rios?
No.
All right. Ms. Howard, again, I want to thank you for being as present as you were in this case and sharing with me what you've gone through. And Mr. Brown, keep doing what you need to do for your son. Okay?
Cheers, Your Honor.
Thank you.
All right.
This one, Judge, we are ready on Mr. Charlie.